I got I was like coming into, I forgot how to bring all this stuff in the office, and I was going home separately. And of course, one thing we're supposed to do, which is all I have.
Chris, we're good? Go on that side. Fine, for you. All right. Thumbs up? Okay, so welcome everyone. Thanks for joining us, especially the Monday after spring break. I know that a lot of you are still getting back to things on campus. It's a very timely day where we're having this discussion on online free speech at a day where the Supreme Court is having hearings on that same topic, and disappointing to some, encouraging to others, I guess, depending on how you read it. And I guess the panel is going to discuss a little bit about this today. So today we have the pleasure to have with us Commissioner Brandon Carr from the FCC. He's a senior Republican in the Federal Communications Commission, having served previously as the FCC General Counsel, nominated by President Trump and President Biden, we confirmed 3 times unanimously by the Senate. Things that we don't hear these days very
Some things slip through the cracks.
I know, right? He brings more than 20 years of experience in the private and public sector on telecom, etc. Has worked in a lot of law firms and also has clerked in the 4th Circuit with Judge Dennis Shett. Joining us after the commissioner's remarks, we're going to have a panel with Judge Glock in the end there, the Director of Research and Senior Fellow of the Manhattan Institute. I guess Judge is maybe 3rd appearance with us in the Salem Center, so I call him friend, I suppose. Ryan Bash from Chief Consumer Protection Division of the Texas Attorney General's Office, and Professor Adam Kendu, Professor of Law at Michigan State University, as well in this discussion. So I guess the way we're going to do it, we're going to have initial remarks by Commissioner Carr, and then we're going to get a sit down, have some discussion, and hopefully open to questions from the audience after that. All right, well, thanks very much, and welcome, Commissioner Carr.
Thanks so much. It's really good to be with you all here. I'm glad to be back in Texas. Always good to visit. I hope we can make this a little bit interactive, at least after my opening filibuster. But the topics that we're here talking about, I think, are so vitally important to the future of the country, which is free speech. And I want to talk a little bit about the value of free speech before getting into my perspective, which is the claim by social media companies that they have carte blanche to censor any speech they want because the First Amendment is not consistent with Supreme Court precedent in this area. But to start with the foundational idea of free speech, one thing that's important to distinguish, but yet has been blurred a lot in this country, is the difference between state action, so government censorship, and private action or censorship by private entities. And what we've seen is actually both of those, and increasingly a blend of those, where you have the government leaning on the private sector to engage in censorship, and there is, a couple of lines of interesting doctrine that collide there, where can the government do indirectly that which is prohibited from doing directly? There's also an interesting line of cases having to do with jawboning, where effectively the courts will sometimes hold that private actors are effectively state actors for purposes of the Constitution, where there is a sufficient amount of control and direction by the government. But I want to start with this concept of free speech, because I think we've been living, particularly the last couple of years, through sort of an unprecedented surge in censorship in this country. And I think there's a couple of contributing factors that have led to that. One is COVID-19. Whenever you have sort of a government in a position of controlling people's lives or engaging in all forms of control, then necessarily there's censorship that comes with that. Because free speech is the counterweight to government control. And this position was once a very much embraced among sort of the left progressives in the country. And my argument is that that's where right now it's been some of the weakest. And I go back not too long from a doctrinal perspective to the 1970s and the New York Times. And there was an editor at the time, this guy by the name of John Oakes. The modern day op-ed actually launched on the pages of the New York Times under his leadership in 1970. The reason was he wanted opinions in the New York Times that were different from the views held by their traditional editors. So up until then, there wasn't the op-ed. And what he said, John Oakes, in his speech, he said, diversity of opinion is the lifeblood of democracy. The moment we start insisting that everybody think the same way we do, our democratic way of life is in jeopardy. Those are his words. He said he wanted to invite people to the pages of the New York Times whose views, in his words, were divergent from that of the Times staff. 1970. Ironically, the space that the op-ed page occupies today, before it occupied there in 1970, was the obituaries, because it was a big profit-making portion of the newspaper was running obituaries for people. Now, flash forward 50 years, a couple years ago, when Senator Tom Cotton had an op-ed that ran in the New York Times, and look at the reaction that took place. People literally lost their jobs for running the opinion of a sitting United States senator. And to me, that's sort of a full circle moment, where when the New York Times, sort of the vanguard of the progressive movement, embracing free speech, embracing diversity of opinions, you flash forward to today, and they're sort of the foot soldiers of censorship, at least when it comes to that Tom Cotton op-ed. I think you can compress those bookends even tighter. Go back to right around the 2012 election. President Obama went to Facebook's headquarters and he gave a speech where he talked about freedom of speech on the internet. And he said that free speech on the internet, 2012, was key to a healthy democracy. Okay? Flash forward 10 years, roughly 2022, President Obama went back a couple miles away from Facebook's headquarters to Stanford, and he gave a speech about how free speech on the internet is a threat to democracy. And so think about, again, those just compressed bookends. Free speech on the internet, healthy democracy, threat to democracy. And what has happened in that period of time between 2012 and 2022? You could attribute a lot of different causes to it. You could look at the 2016 election. I think that's a piece of it. But you can also look closer to sort of 2014 as well, where a lot of this sort of new second wave of innovation on the internet started taking place with social media, where we got the capacity to engage in censorship really on a mass scale. And today, Silicon Valley has more control over more speech than any institution in history. And it was a great democratizing force, free speech on the internet, until we reach this new phase of increased censorship. And so I think fundamentally, this is a cultural issue for the country. We have to return to that 1970s New York Times position of diversity of opinion. My theory as well is that a lot of this censorship is downstream from an extreme version of identity politics. Because once we divide the country into the oppressed and the oppressor, you don't need to have freedom of thought or diversity of opinions. You know what is right and wrong. The oppressor doesn't get to speak, the oppressor is wrong, and you're told what your position should be on various perspectives. So I think part of this acceleration in censorship is downstream for this sort of extreme version of identity politics. Or again, go back to, I guess I'm sort of stuck on President Obama sort of quotes at the time. 2004, Boston DNC. President Obama gave a speech that many people look at as having propelled him to the White House just 4 short years later. A key part of that speech, what President Obama said was, there is no white America or black America. There's no Hispanic America. There's no Asian America. There's only the United States of America. It was a massive applause line, 2004. I would submit to you that if you gave that same line today at the DNC, it would not vault you to the White House 4 years later. It would probably get you going the other way. And I think, again, that's sort of a sign of where we've gone in terms of this sort of extreme version of identity politics and this rejection of diversity of opinion. Again, I would go back to sort of the 1960s, JFK. He sort of said that, what, in a lot of different speeches, what unites us is stronger than what divides us. And I think as a country, that's the path forward, both culturally and for free speech, is to look what unites us. And part of that is embracing diversity of opinion. It's how we solve the country's most pressing problems. We take an issue, we spin it around, we look at it from all different perspectives, and the best idea wins out. While it's a cultural issue, I think law also plays a role. Section 230 is a piece of this. The way Section 230 has been interpreted by the courts, well, let me start with this. In my view, Section 230 does two core things. One, it says if you're going to leave someone else's speech up on the internet, then you're not liable if the speech is tortious or libelous. I think it's a good provision. It's a pro-speech provision. It encourages people to leave speech up. The problem with Section 230, in my view, is 230C2, which I think has been misinterpreted by the courts to effectively stand for the proposition that if you ever take speech down, you get to do it not just with your First Amendment protections, whatever the extent of those are, but with 230 protections as well. So bonus statutory protections for censorship. That's the core, I think, of what we need to change as a matter of public policy. Keep 230C1, basically, if you leave someone's speech up, you get 230 protections. But we should eliminate the extra statutory incentive for censoring speech on the internet that comes from a misinterpretation of 230. I also think we need to impose affirmative anti-discrimination obligations on social media companies, which means for whatever censorship you do, you should not be censoring Americans based on their political, religious, or scientific viewpoints. And this finally gets me back to sort of the crux of what we're supposed to be talking about here, which is the First Amendment. Social media companies will say their content moderation decisions are entirely beyond the reach of the government because of the First Amendment. They say that what they do is no different than a newspaper that the Supreme Court looked at in Miami Herald versus Tornillo, where the court said or suggested, depending on which judge you talk to, that those content moderation, that those editorial judgments are themselves protected by the First Amendment. And what I've argued, and what my fellow Commissioner Simonton has argued in a paper we recently submitted, is that the way to think about the Supreme Court's compelled speech cases is you effectively put them on a continuum, and where these cases lay down on this continuum is the product of consideration of 3 or 4 or 5 key factors. So on the one hand, the one extreme edge of the continuum, I would put Miami Herald versus Tornillo, but there's other cases out there that include Rumsfeld, which is a case about law schools and whether recruiters could have access to law schools for speech that the schools disagreed with. Pruneyard was a shopping center case and whether kids can get access to issue dissenting pamphlets inside a otherwise private shopping mall. Zauderer is another Supreme Court case, a compelled speech case in consumer disclosure context. And there's also Turner, a case that has to do with FCC must carry obligations. If you look at all of these cases and you put them on a kind of continuum, the things that sort of I think make a difference to the Supreme Court based on the case law is the most important factor, I think, is are you holding yourself out in the main as a conduit for other people's speech, or are you making individualized decisions about what speech to carry and on what terms? Again, take the newspapers for the extreme example, where I think the newspaper's First Amendment interests are at their zenith, at their height. Again, we start from this idea that there's a right of a private entity to either physically reject or eject someone from your physical property, or to reject speech that you don't like from your property of a newspaper. A newspaper is basically picking and choosing every single word, every single person that speaks there. It's all pre-screened. Every comma represents the speech of the newspaper itself. But if you slide down that scale and take, for instance, the Turner case, cable systems. In some ways, a cable system has its own channel that it programs, but a cable system in the main really is carrying other people's speech, other people's channels, and they don't insert themselves to pre-screen the content on each of those channels. It's up to other people. And so again, I think when you look at whether you're operating mostly as a conduit for other people's speech, or if you're making individualized decisions, that helps inform whether the government can step in and pass a law to survive Supreme Court First Amendment scrutiny that would otherwise interfere with that traditional private right to exclude. I think Texas is a great example of this. They passed a law, HB 20, that prohibited social media companies from engaging in viewpoint discrimination. And again, I think whatever you think of cable systems and whether Turner would be upheld as applied to cable today, I think social media stands in the shoes of where cable stood when the Supreme Court decided Turner. That basically, this is another one of the factors, is that the centrality of your medium to political discourse is relevant, I think, to the First Amendment analysis. Back in the days that Supreme Court decided Turner, you had to be on a cable channel effectively to be able to disseminate your speech. Today, if you're not on social media, good luck getting your message out there, whether it's political, religious, or scientific. So I think the gatekeeper control that social media plays today with respect to the public town square that is social media means that their right to have carte blanche to decide who gets to participate and who doesn't is diminished. Final point. My position is not that there should be no point in our system in which a particular viewpoint or particular words even get to be censored. The question I think we need to ask, though, is at what point in the system should that censorship take place? And what I mean by that is this. There's effectively 2 points that it can take place. Do you want the decisions to be made about who gets to speak and what they can say to be made in a single centralized point, usually in Silicon Valley, or do we want to distribute that power amongst people? My view is that the participants in the digital town square should be the ones that get to decide ideas that they think are worthy or not. And the way we do that is we give people tools like blocking people, like muting people, like boosting the words of people that you do like. I think when you take that power of silencing, of censoring ideas, again, one entity where you make a binary decision, censor or don't. You get it right, okay, I guess, good for you. And we focus a lot on quote unquote the harms that come from speech that we don't like. But think about the other side. Think about all the harms that flow when you take a good idea, a valid idea, an interesting perspective, and you shut it down as original matter. Should we have public debate about the origins of COVID, or can we not have that debate? Can we talk about the value of masking for young kids that don't have a high susceptibility to COVID and are learning speech at a young age? Can we have a debate about the value of masking for them? Can we talk about the Hunter Biden laptop story? Is it Russian disinformation or is it something else? When those decisions are made at a centralized point and they get it wrong, real harms that flow from that. And so again, I think you distribute that decision making to individual people, let them decide who to follow, who to block, who to mute, who not to. And I think that's the best path forward for us, is to re-empower that. Because just like with the government, we try to limit the power that a government has because of the errors that the government can make in the exercise of it. I think we see the same thing in Silicon Valley. So we need to distribute that power back out to the people. And I think, again, that'll get us back to the idea of being willing to listen to an idea that we don't like, listen to a diversity of opinion. And I think going forward, that's how we solve our problem. So again, I think it's cultural. I think we got to get back to an embrace of free speech in this country, but it's also law because it's reinforced by Section 230, this concept of censorship. And so I think state efforts like Texas's to step in and promote a diversity of viewpoint, given the unique way that social media operates today, is not only constitutional in the First Amendment, but it's the right thing for us to do. So with that as my filibuster, I don't know if I went too long or too short, but I got most of my content out. I'll turn it over to the next up, and I'm happy to have sort of a back and forth as well. Thanks.
Oh, okay. I don't have much to add to the commissioner's discussion, because I thought it was pretty expansive and really got the issues out there that we're facing right now. But this year is actually a big year for decisions about what the internet is going to look like and free speech. Starting with here in Texas, HB 20. So HB 20 was a law that was passed by the Texas legislature. Brian Hughes was the sponsor, and it said that the platforms cannot discriminate on the basis of viewpoint. So they can't kick you off if you're Presbyterian, they can't boost you because you're gay or Catholic or whatever. They have to treat you like the telephone companies treat you. If you want a telephone company, if you want a telephone, they have to give you a telephone, whatever color you are, whatever religion you are. And this this case was litigated by Ryan Bash here. Did a wonderful job for the Fifth Circuit, and it was upheld. And the reasoning of the court goes to the distinction between a newspaper and a telephone. When you talk to someone on the telephone, it's not Verizon speech, it's your speech. And so therefore, regulation on the conduct of how Verizon has to offer its services is not First Amendment protected. It's just like any other business. Similarly, when Facebook or Twitter offers you an account, you're primarily talking to your friends, to your moms, telling you what to do and things like that. You're not talking to Elon Musk. Well, some people in this room, but generally, it's just talking to your friends, and it's just a telephone conversation with a bunch of people. And so, government is in the position to say, look, this is a service you're offering to all these people. You have to do it in a fair way, and follow the discrimination laws that every other retail company, every other public-facing company has to follow. You go into Walmart, they can't discriminate against you because you're gay or you're Jewish or you're short. You go into any retail or public-facing company. So why should Twitter or Facebook be different? And this was litigated just the oral argument was just a few months ago at the Supreme Court, and it was a very interesting discussion because you see a real tension within the conservative movement that I think might be reflected in this panel. I think it'll be interesting if it is, between those who say, look, I'm being unfair to my opponents, but it won't be the first time. Their view about the First Amendment is, it's like the boomer, get off my lawn. If I own the wires, everything that goes over my wires, I get to control. It's my property, my speech. There's a conflation of property rights and speech rights. On the other hand, this is a view that some people, Republicans and writers, saying, look, traditionally that's never been the law. Telephone companies can't do that. Cable systems don't have an absolute right to exclude. Retail business can't kick you out. Employers, under most state laws, can't fire you for the basis of your political views or what you express. And that's because, and I think we have this protection. By the way, how long do I have? I don't want to go. Okay, so I'll be short. Yeah, and I think that this is a real sort of tension in sort of the Republican right side, because the line between public and private has really been blurred. Thanks to the administrative state, you have these huge DEI entities and large corporations. You have these huge compliance costs. And in a way, they're being paid by private industry, but who are they really working for? They're working for the government. Because they are enforcing the government's rules. And I think we see that in social media companies. There's a tremendous revolving door between the FBI and CISA and these strange connections. And then the last thing I'll talk about is another important case, which was Murphy v. Missouri. It was argued just today. And that had to do with the Twitter files. Anyone familiar with them, the Twitter files? And the question was, well, given the fact that the White House was constantly calling up Twitter and Facebook and saying, censor Jay Bhattacharya from Stanford because he's disagreeing with the COVID response. Of course, everything that Jay Bhattacharya said turned out to be true, but nonetheless, he was censored from Facebook and Twitter. And the question was, when government puts pressure on these platforms, do these platforms become state actors and therefore subject to the First Amendment? And that goes to this real public-private distinction. At what point does the pressure on government becomes so great that they essentially become the minions of the state. And again, I think that goes to a deeper question, deeper political and social question, which is in the age of the administrative state, when so much of what these big corporations do is really at the behest of the control of government, what is private and what is public? So that further ado, I'll hand over to Ryan.
So I'm gonna start by picking up where on a point where Commissioner Carr emphasized a few times, which is the relevance of Section 230 to this discussion, which I think is actually at the core of the whole problem and has in many ways caused the problem. I'll kick it up a level of generality because I gather there's probably not many lawyers in the room, and I think there's a very common sense intuition here that can help people weed their way through the doctrine and the precedent, Section 230, whatever that means, and kind of come to a conclusion for themselves about what the right answer is. And namely, it starts by just asking yourselves, who is speaking? When the platform censors its users, or when the user themselves speak, is that in some sense the platform's speech? Is it attributed to the platform? If it is, then it makes sense to say the platform can control it. So, by comparison, newspapers, when they publish something by a third-party speaker, an editorial, I think most people's impulse is to say, okay, the New York Times kind of said that, right? And if you share that impulse with Facebook, maybe it makes sense to say Facebook has the same control over that content as the newspaper. But if that's your answer, there should be a consequence. Namely, with newspapers, they're responsible for everything that they publish. If Tom Cotton publishes something in the New York Times and he defames someone in that publication, not just Tom Cotton, but the New York Times is liable for what Tom Cotton did. This is where Section 230 becomes very relevant here, because Section 230 for 28 years now has given social media platforms and the predecessors online this protection that you're not responsible for what people say on your platform. You can't be held liable if Facebook user A defames Facebook user B. And I think the reason why we've thought for a long time that makes sense, I think the reason why Congress passed that law 28 years ago is this impulse of, it's not the platform's speech. It's not Facebook's speech, or in 1996, the predecessors, message boards, whatever. It's not their speech, so it doesn't make sense to hold them accountable for it. And so Section 230 is going to protect them and say that they shouldn't be held liable for it. But now you've got this dynamic where the platforms, internet entities, are claiming, on the one hand, it is kind of their speech, and so the First Amendment allows them to control it. But then on the other hand, it's not really their speech under Section 230, and so they're still immune from it. This came up a lot during the Supreme Court argument a couple of weeks ago. I like to say it's kind of a poison pill for the platforms, where if they win on the First Amendment, they're doomed, I hope, on Section 230. And a number of justices asked them, how can you have it both ways? And the advocate for the social media platform said, well, it's our speech for the First Amendment, but under Section 230, it's not our speech, and here's how. And Justice Gorsuch had this really good line, I think, that drives the point home of well, so what you're saying is there's speech and then there's speech, right? And that just can't be right. I think that's the impulse that I've had since I first came to this, and I think that they have to choose. And in the end, if they are forced to choose, they're going to say, we want the liability protections. We'll give up on controlling it. We'll stop censoring it. We just want the liability protections. And I think that makes sense.
Okay, clap for everybody. You clap for everybody else. Just because you didn't stand up doesn't mean you should clap. Because I won't stand up either, so I want to clap at the end too. Thank you everybody so much for coming out on this. And I do worry that I am the lone defender of the free market in this particular situation here. In that case, one does have to worry that one is supposed to be the foil, and then the organizers of the panel assume that you weren't that bright, and therefore you can make the other panelists look particularly sharp. So with that concern in my mind, I would like to differentiate my position just a little bit from the stark, diehard libertarian stance. TikTok should not be owned by the Chinese Communist Party. I think that's something a lot of us can agree. I've yet to hear a conservative crowd boo that one. The government should not force tech platforms to censor themselves. The Murthy v. Missouri case is a concerning case, and I'm concerned about how the justice looked at that. And I'm concerned about how the justices seem unconcerned that the government was specifically holding up these platforms' Section 230 advantages as a way to get them to take down what we now know were largely true and accurate representation of the COVID circumstance. Yeah, we got a little clap there, why not? And finally, I agree fundamentally with the commissioner. This is basically a cultural problem before it is anything else. Whether or not we think there is a legal issue at stake here, I think all of us should be very concerned about the James Bennett firing the New York Times op-ed page, which they had a complete and utter legal right to do because he posted an op-ed by, yes, a sitting United States senator. As James Bennett recently wrote in The Economist, I encourage you to actually read his article there. He was mystified how he got fired for posting a U.S. senator op-ed, but the New York Times got no response for posting a Chinese Communist Party op-ed about why they need to crack down on Hong Kong. But such is the current culture of free speech in America, which should concern all of us whether or not there is a legal issue at stake here. But I think a fundamental other conservative position is that for every culture or cultural or other problem in our society, there is not a clear governmental answer for it. The slow and clumsy hand of the state cannot solve all of our social problems, cannot solve our cultural problems, and cannot make people at the New York Times or elsewhere believe that they should accept a diversity of opinion. Now, that gets to the question of, we do have a history in this country when we do think the government can intervene, and I think some other panelists have discussed a little bit about that. They've discussed things like cable, things like the telegraph wires, actually, which came up in the oral arguments over the Texas HB 20 law and other laws. Discussed things like the spectrum, the government television stations. And these are all areas where historically the government has some ability to regulate that they wouldn't have if it's just a typical private property business in a local supermarket or wherever it is. Now, one thing though is interesting looking at these other areas that we've regulated that are probably most analogous to what we're talking about today is they are largely the wires and pipes that the information flows along. And now I know the other panelists sitting right here have also generally, I think, have all talked about the problems with the net neutrality regulations that previously went out under the Federal Communications Commission. And they tried to regulate the pipes or wires of the internet, but they were allowing people who subscribe to those internet service providers could see and demanded that they carry basically all different sorts of information equally across their platforms. And to my mind, conservatives rightfully railed against this attempt to say that these internet service providers, Comcast and the rest, are private providers, they're private property. The government should not be involved in managing how these different ISPs manage their own networks, even though to my mind, they had a much stronger case than the case against the social networks. Now, the social networks are not the pipes or the wires that all of these other analogies were generally talking about. They are the things that are carried across the wires. The argument for why the government has regulated common carriage, as it's known, or common carriers, is because they were what was called as natural monopolies. A natural monopoly is something with a continuously declining average cost, something where it's easier and cheaper to build the last railroad mile than the first railroad mile, and therefore it tends to only have a single or at most two different competitors in the market. The argument against social networks is not that they're natural monopolies, because they aren't. The argument is that they're network. They have a strong network effects, meaning it's very beneficial to have lots of different people on them, and therefore there's benefits to people all being on a centralized marketplace as opposed to a diverse number of different marketplaces. But now, unlike the pipes or wires example, we know that whatever the concentration of this market, you can go on different social networks. In fact, most people, I would guess in this room, have gone on numerous social networks today. One of the fundamental arguments against monopoly or about certain areas that are monopolized is you have high switching costs. You can't move from A to B. Again, many of us do it many times in an hour. And whatever you think of the concentration of social networks, they are changing constantly. I don't need to just bring up MySpace and Friendster and Tumblr and all of the ones that have fallen and risen in the past 20 years. We can talk about Facebook itself, whose portion of the social media market has dropped by about a third over the past 5 years, mainly because of the rise of TikTok. Now bracket the Chinese Communist Party thing right now. Is this a fairly competitive marketplace that is completely monopolized and does not allow people to switch to different service providers? I don't think so. This seems like the sort of thing we can trust the free market to regulate and to figure out. We can see this partially with Musk buying up Twitter. There is a market for corporate control, just like there's also a market in between these different social networks. Now, yes, we can regulate certain kinds of these natural monopolies, but we regulate and demand impositions on these social networks. There seem to be incredibly dynamic and much more dynamic than anything the conservatives have rightfully refused to regulate in the past, like the internet service providers. I think we can. I think we can trust the social networks and the market to generally figure these problems out without the slow and clumsy hand of the government telling them how to operate their networks, telling them how to run their algorithms, even if, again, we disagree with how they're actually doing it in practice, which I agree with my fellow panelists on. Thank you. I'll take even if it was the mayor.
I'm going
Should
over
we
your questions.
respond to each other maybe first and then we'll go for questions, or?
Yeah, let them beat me up for a few minutes, then we can
Well, I
answer
mean,
other people.
I guess 3-on-1 might be better to do the questions. I like a lot of what he said. You know, net neutrality is an interesting point, and people say, well, how do you square my position? I voted repeatedly against sort of Title II and neutrality. How do you square that with this? And a couple sort of points to distinguish that. So, for those of you that don't know, net neutrality is sort of two things combined into one. The first thing is we have this set of regulations at the FCC under the Communications Act called Title II. Title II ultimately has as its origin regulation of railroads, sort of where that came from. It's the idea that you must heavily regulate a monopoly provider. That's Title II. So it includes within Title II things like rate regulation, which is sort of the sine qua non of heavy-handed regulation. And then you have something called Title I, which is sort of a very light regulatory framework. For 20 years since its inception, the internet was regulated under Title I, so light regulation, no threat of rate regulation, and that helped contribute to this massive investment in the internet. Last 2 years of President Obama's administration, the FCC reversed course and for the first time applied Title II regulations to the internet. It had a lot of, in my view, harm that came from the potential of rate regulation. A lot of people thought maybe the FCC can do rate regulation now. Once the FCC applied Title II to the internet, it then hung net neutrality rules off that new legal framework. And there's actually not that much controversy about net neutrality rules, meaning no blocking, no throttling, no unreasonable discrimination. The main issue has to do with that Title II framework or not. If Congress passed a rifle shot net neutrality bill, it's something that I would support. We could do net neutrality without the harm of sort of price controls that come. But how more directly do you square that with this? When the FCC did its Title II decision, it expressly refrained from making a finding of market power, probably because it's very difficult in the ISP context, in part because we have a lot of competition. You know, people don't think so. You know, people are always mad at their local internet provider. There is a lot of competition for the internet. For instance, in your home, you can probably switch from looking at your phone and having 5G internet from a wireless carrier to flipping a button to turn your Wi-Fi on and getting a cable or a wired connection. So with the flip of a switch, you get competition. And so that's one key distinguisher from net neutrality to my position on social media, is I do think, and he made a great counter argument about substitutability in social media, but I think that you can easily make a finding of market power in social media, because while there is other options, the product and the thing, in my view, is sort of sufficiently different, but there's reasonable people, as one sitting right here does, that makes a counterpoint. With ISPs, when you flip between Verizon, 5G, and Comcast, in-home, it's the exact same product, sort of complete substitutability. So I do think there's some unique features that make Title II and net neutrality something that you can distinguish from the position that I have, but it's a fair point and a fair tension to be raised and sort of talked through. So, but yeah, with that, happy to open it up.
So let's say that we do decide that these platforms have to decide, as one I forget who, between their ability to censor and their liability protection.
Or there's a third way, they get to keep doing all of it.
Right, but let's say we make them choose.
Right.
And if they choose, as was predicted, their liability protection. Where do we draw the line? So I guess, just as an example, if I want to start a social media platform that is completely dedicated to just something silly, like cat memes or whatever, and I want to exclude speech about anything other than the topic of my platform, Am I allowed to do that in a world where we said you can't censor speech, you can't make editorial decisions about what speech is allowed?
It's a good point. I think, Professor Candy has spoken this a lot, which is you can draw a line between sort of general use, general purpose social media and sort of bespoke, specialized context. And there's several ways in which you can draw that line that I think would be a rebuttal to the argument of, is it a slippery slope? Are there hard edge cases? There's gonna be hard edge cases, but I think you can generally draw two different worlds. So for instance, comment sections on websites, we sort of all, I think, generally agree, you can sort of carve that out. You can put a user number, millions of users, to sort of carve out sort of smaller, specialized websites. So I do think there's a way that you can proceed that if you want to say, hey, look, this is my editorial perspective, this is my political bent, I'm going to edit pursuant to that, I think you can have a place where that continues. And that's also ultimately how you get back to the Colorado cake baker case, right? Where someone says, own a Colorado cake shop, and it's been years and years and years of litigation, people coming in saying, I want you to make a cake for this thing. This thing happened to be something that cake baker doesn't agree with socially or religiously or whatever. The state keeps trying to compel them to make that cake. I would say that is the type of example that the lines that I'm drawing would allow. That, like, if you have something that you are imbuing, in that case, with sort of artistic skill set, where you're sort of a small one-off bake shop, where you have your viewpoint, you've made it clear, then you're carved out. But when you're talking about Twitter and Facebook and YouTube,
You're talking about Reddit in particular?
You can talk about subreddits. You can sort of carve out, I think, for the same type of idea. But if you're a general use social media that say, and they say this, we don't engage in viewpoint discrimination, then okay, you should be held to not engaging in viewpoint discrimination. But the other ones below that level should continue to have a lot of discretion. But I don't mean to filibuster. I know you spent a lot of time thinking about this.
Yeah, I mean, first of all, a lot of the all of the laws, like Texas social media laws, have very high thresholds of 50 or 60 million users.
But under the current national legal system, there's no justification for drawing a line at some arbitrary level.
No, there are plenty of laws that set a line that, as long as it's relatively rational and satisfies reasonable rational basis standards. So, and that argument would be, look, any communications platform that is that big probably is a general purpose platform like a telephone. Second, Twitter says it's the free speech wing of the free speech party. YouTube says it's all about connecting people to one another. These are the representations that people have depended upon when building their own sites and their own following. And that's the way it's been successful. Now, if you want to start a Christian social media company, I think it'd be very different, because that has a clear, expressive point of view. It's not holding itself out as a conduit for all speech. Now, Facebook will then say, well, we're just a conduit for the speech that we like. And that actually is a very old conflict that goes back to the 19th century in railroads. And the question is, well, if we're making a general offering, can we therefore say, well, it's not a general offering, it's only the general offering that we want? And then we apply a rule of reason, which is, we look at what they're actually doing. We look at the regulatory burden of making them serve everybody, and courts make judgment. I think that if we require Facebook to stop discriminating, what message that Facebook is trying to make would it not be able to make? And I think the answer is nothing. On the other hand, a lot of people in this democracy would be shut out. Particularly in this highly polarized environment, when Facebook is controlled by an elite that doesn't really share the values of most of us, or a lot of us. So those are the sort of distinctions you make, but they've been made for hundreds of years and they work relatively well.
Mike, so it sounds like a lot of basis is the First Amendment, and in the First Amendment it says Congress shall make no law prohibiting the free speech of the people. But then, is that a flaw in the First Amendment? Should it also apply to private companies when they get to a certain size? Or is that your view? Or does the First Amendment only apply to government?
Well, the First Amendment operates as a restraint against the government. And so the way it comes up is, the government will pass a law or regulation like HB 20, and the private actor will say, you are restrained by the First Amendment interfering with my, right to discriminate in my form of content moderation. But if you look at all the Supreme Court cases in here, that sort of traditional right to exclude speech or people has historically always been tolerated by the Supreme Court, the First Amendment notwithstanding. So again, you go back to Turner, which was a cable system, right? Let's say a cable system has 40 channels. Historically, you would think that the cable system owner would have an unfettered right to decide who gets to use the channels or not. But that's not the case. We require them to keep certain channels open for, government channels. We prohibit them from discriminating in favor of sort of vertically integrated, affiliated channels versus others. So it was right that a private property owner has carte blanche on the First Amendment to pick and choose what speech to carry or not, then Turner will come out differently. And I guess the same argument with Rumsfeld, the same argument with Pruneyard. So we have always sort of tolerated in certain circumstances some government conditioning on your right to exclude, whether it's people or right. I don't know if you
No, I mean, I agree with most of that, and you've already also, the commissioner's already brought up some of the counterexamples where the Supreme Court has struck down laws that try to mandate equal access, or PG&E. There's the Hurley case, which was a parade involving whether a parade could exclude certain groups, even I think it was an Irish American parade.
Yeah.
And
timely.
Yes, very timely, perfect time on this. And Tornillo, which was the Miami Herald case. And some people would argue that, well, the distinction there is something about market power, where you can make a very strong argument that Facebook, especially with Instagram and WhatsApp together, have an extreme amount of market power. Other people like me might argue this is a little more about sort of common carrier history, where the sort of things that you required, the sort of companies you required everyone to come on board with were inns, railroads, canals, etc. They were required to treat everyone equally, and all of the sort of common carriers in the common law historically looked a lot more what like economists would call these kind of natural monopolies, as opposed to these more modern terminology, which is these network effects, which frankly economists and industrial organization specialists are still working out exactly how these network effects work out. But one final thing I would say on that is to the argument that, well, the government is involved with these, and so therefore it has a right to sort of control who comes on and what the sort of processes are. I think we'd all agree on this panel that, again, the government cannot push somebody, some private company, to exclude certain kinds of speech. Whether or not in this particular Murthy case, they've actually done that is an important and detailed factual question. But I think we all agree that the government should not use its coercive power to push people off. But we don't want to go the other side and say, hey, the government is involved in creating these sorts of medium. They've been involved historically and how they work. Maybe they've helped create the ISPs, the wires that carry the information along, and therefore the government has all sorts of power to get involved in it. That's been the progressive argument about why we need to regulate the economy for 150 years. That, hey, the government, your private company it was built on roads the government built. The air that you breathe is kept safe by the government. Therefore, you're basically all state actors when you really think about it. We don't want to go down that route. We don't want to say
you didn't build that theory.
Yeah, exactly. No, I was trying to avoid using the involvement term, but you're absolutely right. That's you didn't build that theory. We're all state actors because we're all intermeshed with this administrative state that's very involved with our private lives at this point in a way it wasn't. But we don't want to take that step, and therefore, effectively, we don't have private activities, private property, private rights, because they're all intermeshed with the government. We should stay away from that.
Okay, if I can just follow up on the last conversation, I think to clarify, nobody, and I don't want to speak for everyone, is saying that the First Amendment means that Facebook can censor us. Facebook is saying that the First Amendment cannot prohibit the state from passing laws saying that they're not allowed to censor. So there was a brief period of time from 1948 to about 1970 when the Supreme Court did have these limited cases like company towns and shopping malls where they said it's the First Amendment right, and then the Supreme Court more or less overturned those decisions. But then the state of California said, Well, we have a law which says the same thing. Supreme Court says it's fine for a state to expand First Amendment free speech rights beyond what the First Amendment does. And that's kind of the framework that we're doing. And then just to kind of build on that and disagree with Judge, so the question is, I get the idea that, the government is money, therefore you should have First Amendment rights, that's not really how it should be. But, there is a concept of kind of joint ventures between the government and social media, and the case I bring up is the before Trump got kicked off of Twitter, when he was not allowed to block people from his comment section. And so the government basically uses social media to have, Facebook town halls, Twitter town halls, YouTube, and so when
It was just a 9-0, I think.
Yep,
Last week.
Or last week, yeah.
Last week it said.
A public official cannot exclude people
Yeah.
from his, block people because
So-
that was a public
So
forum.
the issue now then becomes, if you are basically doing your communication with your citizens, allowing them to respond on a private forum. So yeah, the government cannot delete your Facebook comments to your post, but the government can say, I'm going to do all my communication with my citizens on Facebook, and Facebook happens to censor all the people who disagree with it. So I would say it'd be the equivalent of saying, I'm going to have a physical town hall meeting at a country club that just happens to exclude Black members, and this is just private, this is private action, not state action. So then how do you kind of address the fact that the government is actually using these social media platforms to communicate with citizens, and then they'll censor it, and so many citizens are basically blocking these kind of people.
Yeah, I mean, I think those are fair points, and I would respond first that I think we're pretty in synchronicity over here about, say, the Murphy case, which is about whether or not the government can force the private actors to censor on their platforms. They should not be allowed to do that. And again, it's a difficult factual question whether or not that's what they actually did here. I think they did, but we can bracket that aside. The basic conceptual question, I think we're in agreement on. For the other question about the public forum, as the commissioner just said, they just had a case on this. And I think, again, that was kind of a close case, but it was a city manager who was blocking people from his Facebook account. And people said, and the Supreme Court unanimously said, hey, you have a right to hear this. This is your communicating official information. And the Supreme Court, I think by Justice Barrett, was very clear that, well, this was also factual. It depends on how much information you post. It depends on when you do it, and whether or not you should be allowed to use your private your private profile, your private citizen profile to block these people. Again, I think bracketing those sorts of things are fine, and I think we're largely in agreement about that. I mean, to the wider question though of what the government should be able to do, like that Pruneyard case, which, as you mentioned, was the California state saying we're going to force a private shopping mall to allow different people to pamphlet and do other things in the private shopping mall. To my mind, that was a classic example of progressive overreach. And yes, the Supreme Court upheld it as a rational basis review of what the state can be able to do. But that also, for my mind, one, that's a questionable sort of decision in itself, whether or not the Supreme Court is going to allow the states to do that sort of thing on private property. But two, whether or not it's a good policy, in my mind, is also therefore an open question. In general, there was lots of shopping malls. In fact, I think one of my favorite Congresswoman officials looked up after the Pruneyard case and looked, well, what happened? Do you see a lot of pamphleteering on these shopping malls? No, they have little quiet ways in which they encourage people to go pamphleteer somewhere else and something. Because in general, the government's not very good at deciding how to manage public spaces that are actually run by private actors, and not good at deciding the best algorithm for Facebook or whatever it is. And so I think we can, take some of these questions and kind of distinguish them.
Over there in the back. This is another question for Rod. In the last three elections, 2016, 18, 20 political election cycles, do you think that the major social media networks offered the forums for a true diversity of political discourse that's mentioned as a justification for Section 230? And if not, without further regulation, when would you expect the free market to deliver such a model?
I'm like bracketing all the questions, so you don't have to answer the difficult ones. But I'm going to keep 230 on the side for that. And I think whether or not that's the correct policy, I think is this whole other debate that we can get into. Whether or not they were providing the diversity of viewpoints we want, frankly, I just don't think that's a government issue. I mean, historically, you look back, and the right wing had a lot of advantages in media. If you look back, I think Ed Glazer and some others had some historical economic papers that showed, hey, you know, the Republicans had a lot more money to fund papers in the early 20th century. And this was driving the Democrats out of their mind. Like, you're using this private power to influence the American populace, and you had kind of demagogues like Hearst who were controlling large sections of the national media market. And they said, well, what can we do about this? You're trying to force them to carry certain things. You're trying to take away, historically, the FCC took away some of these newspapers' privileges to own connected radio markets, or conditioned their radio station ownership on giving certain favors to the government in power and so forth. And that's the thing I just don't want the government involved in. I don't want them to say, we have this side of the media market is giving too much weight to this viewpoint and not to the viewpoint I think they should give the right weight to.
Yeah, if I could just respond to that. I mean, I think that's sort of like the generic knee-jerk libertarian reaction. I not think it's quite appropriate. The answer is, well, okay, the market will work it out and we'll get new platforms and they'll be able to have a diversity of views. Well, that's not the way that it seems like these markets are working. We have serial monopolies. Google, YouTube, YouTube, Facebook, yes, but now it's all Instagram and there's no about seeing people. My favorite example of is there market power in real market power in social media is, of course, Twitter or X. I mean, all the left liberals hate Elon Musk, but they can't get off Twitter. I mean, they're too addicted to it. Now, why is that? Because of network effects and market power? I think so. And that the problem that we have, the problem for libertarians, is that certain institutions keep the political structures going, that keeps the economy going. In other words, when you stop having free speech, you don't get functioning government, and eventually you won't get judges and judiciaries that treat people fairly, and you don't get contracts, and the whole system collapses. And so that means we can invest a little bit in making sure that people are allowed to express themselves in a democracy. Now, I agree, what FDR did with saying, no, you can't have a radio license or a TV license because I don't like you as a newspaper. That was a bad thing. That was a wicked thing. On the other hand, these common carrier non-discrimination laws, which are historically not really based on market power, go back to the 14th, 15th century on that, forgive the pedantry. But these are very mild common law rules that have restricted market, regulated market activity for hundreds of years, and the world never collapsed. In fact, the 19th century judges, the Latin judges who hated government regulation, they like common carrier because they recognize that there are certain functions that are necessary for the structure of our democracy.
The other, counter that I've heard, and I sort of agree with the rest of saying, but the other counter is one, that language is sort of just surplusage or prefatory. It's not sort of operative language. It doesn't say, truth shall exist if this diversity of viewpoints doesn't materialize. The other one I've heard is people have looked at that language and said, but they don't mean as to an individual site. So you got, Fox News and MSNBC, websites, and so we have a true diversity because the internet itself has across all these things a true diversity. You don't need to find diversity of opinions on Facebook or on, one particular site. Is one counter.
I think on another point of view, I'd like to sort of look at it in the business point of view when it comes to social media, particularly the removal of censorship, and the way it would affect advertisers, and particularly profitability of a lot of social media. And I think I'd like to use Twitter, for example, the case study where we see that once censorship was removed from the platform, we see a lot of these advertisers leave the platform and sort of leave it just to meet cultural norms. And so when we discuss sort of the profitability of these companies, shouldn't the free market decide whether they should go?
Well, a couple things. I think one, the assumption that there's been less censorship on Twitter and that advertisers have fled as a result of that. I think you have to break down both of those pieces. It's not clear to me that there's been less censorship on Twitter of the type of content that people would point to for advertisers fleeing. Like people said, there's been a rise in hate speech, a rise in racism. I think there's been counter studies to show that that's not at all what's happened. In fact, in some instances where there was evidence of that, the facts showed that it was manufactured by certain entities. In fact, there's a lawsuit over that right now. Again, I think in the main, what you saw with Elon Musk was that Musk himself became a lightning rod, and it became a social signal by some companies to decide not to do business with him. So I think it's not quite an example, in my view, of less censorship, market punish. I think there was something else going on in that particular instance.
And one thing, this is something for business students is, one answer to this whole problem of content moderation is just giving people greater tools to control the content they see. And yet, curiously, platforms don't seem to want to do that. That's a solution they're not pushing for.
And the other point about market, an efficient market punishing here is the same companies that pulled advertising from X or Twitter either went on or stayed on TikTok, which Congress in bipartisan way says is beholden to the CCP. So again, I think there's something odd happening that is different than an efficient market responding to censorship or not. That just has to do with lightning rod personalities like Trump, like Elon Musk, that it has become sort of a thing to sort of reject it among sort of C-suites.
What laws have you put in place to ensure the fact that Christian leaders can share the gospel? What censorship is continuing? This is a Supreme Court. It's a Christian nation, and it's the values, certainly testing on the values based on the Bible. What ensures the Christian message continues on all that?
Yeah, I think when we talk about limiting censorship of viewpoints, again, there's three core types of viewpoints that I have in mind: religious, scientific, political viewpoints. Again, the baseline starting position, putting social media aside, is the government can't stop an individual from expressing and proselytizing their religion, but they can't compel a private entity to host that speech or to align with that speech. That's the baseline. But again, I think that baseline is rightfully different on social media because social media holds themselves out as general use. So I think in that context, I think the government should step in as HB 20 did, Texas law, and so you can't discriminate against religious viewpoints. But if you stay with that baseline position, then I think you'd be not in the same spot as HB 20. But
I mean, I think this also brings up another issue that we may agree on, but to my mind, clarifies some of the issues at stake at HB 20 and some of the others. Some of the supporters of HB 20 have said, well, look, you wouldn't allow a private railroad or cable company to discriminate you based on your religion or your gender or your race or whatever it is. And in general, I think we're all supportive that the social networks should not do that based on your innate characteristics, who you are. But that is a separate question from whether or not you can say certain things and expect them to be boosted or shared in a certain manner on that same social network. If you look historically at these sort of regulations that we're analogizing HB 20 or the other recent social media laws to about inns or railroads, they said, yes, you have to let everyone on your railroad, but you don't have to let them say whatever they want when they get on the railroad or do what the conduct or speech they think is appropriate for that. That was a separate issue that really didn't come up until, again, to my mind, some of these more left-wing activist sort of rulings and laws about prune yard and speech and so forth. And so we can agree about, hey, let's not have social media companies discriminate based on your characteristics, but that's a separate issue from what you say online and who you expect that to be shared with, because that's also very difficult. When you look at the law on these things, it says, well, you can't deplatform, but you also can't de-emphasize and sort of that. Now, everything these social networks do is boosting this opinion, lowering that one based on what they think you would like or wouldn't like. These are very difficult questions. Again, then all of a sudden we get a bunch of different judges in different parts of the state of Texas or Florida deciding, well, this is the right amount of boosting for this sort of speech, or this is the wrong amount. That's when I get very concerned about the government getting involved.
Let me follow up with the question. Oh, so go ahead.
I'll make mine very quick. It's a very good question. I think a lot of people don't really realize what the stakes are, what the social media companies argue the First Amendment lets them do. A lot of people think censorship, oh, that's just about hate speech, right? The social media platforms want to take down hate speech. What do I care, right? But that's not really the extent of their argument. They've even said that if we, the platforms, want to take down religious speech we don't like, we've got a right to do that. That's how far their argument extends. And really probably even broader than that. They said in the court a few weeks ago, they've got the right to delete your emails. They literally said that. So imagine your emails about religious speech. They think that they've got a First Amendment right to delete that stuff. So our law would protect religious viewpoints, but the social media platforms think that they've got a right to censor that stuff.
I think that those are, to me, easier cases, but like, that's absurd. That claim is absurd to your email, but when it comes to the throttling, that's what the judge is talking about, like the fact that we're talking about an algorithm, right? That you write down, they try to give preference to this versus that, and forget about their preferences on speech, whether they're left, right, whether they're religious or not, and think about their sort of like objective of making money. It's a marketplace in two directions. Not only are they trying to throttle things up in order to be able to sell advertisement at a higher value added, and therefore there's a reason to do it given the preference of the people in the network. They're just looking at optimization, right? And on the other hand, people that are participating in that, and I think might lead to a different question, they are also participating in the marketplace now, right? A lot of people monetize their presence on Facebook, on Twitter, on YouTube as a marketplace for them as well. So it's almost like Amazon, having not the ability. Imagine if Amazon couldn't rank order things, when you look for a certain product, right? So because people are like selling their content through those platforms as well. So does that complicate things a little bit? It's not only about speech, right? It's about this commerce that's taking place on these platforms, and I don't know how you think about that. In light of Section 20 or any of these cases, we didn't talk about that aspect yet. This is a commercial aspect.
Well, I think it reinforces in the sense that I think the idea is that when you hold yourself out to the public as providing a service that doesn't discriminate in certain ways, people come to that platform, they build their business, they invest in it. Or if you're just even a website, and your traffic and how people get you is dictated by being able to find you through Google. And overnight, Google can change the algorithm and send 90% of your traffic somewhere else, or kick you off if you built a business. And I think that's a consideration at least in favor of not having censorship.
I think it's an interesting question. This didn't come up with the argument too much, unfortunately, but they have the First Amendment right that they claim that they have. That would allow them to manipulate, it would allow Amazon to manipulate results for commercial products, in theory, right? Amazon, the argument would go like this. Amazon would say, well, when we sort products, we're expressing something about how we feel about those products. We've got a right to do that. We can bury our competitors' products and boost our own products. That's not quite the argument that was at the focus of the court's hearing a few weeks ago. But in theory, that's where the logic extends.
Right. At least the one next is, does the First Amendment trump antitrust law? So, Twitter doesn't want to link to competitor services. Well, it's not only an antitrust question, but it's a question of expression, because they're expressing their linking spike that they have. I think it is a very, very important question. But I would say anti-discrimination laws suffuse the entire economy, and we haven't collapsed from them yet. It seems to me that it probably could be worked out without the end of the world.
Well, But these answers are largely dealing with the legal question again, right? People are focused on, the other panelists are focused on whether or not the First Amendment can restrict the government, a state government or the federal government from mandating these sorts of discrimination things. And I admit that's a somewhat closer question than I think that the issue that I'm mainly focused on, which is that good policy though? Should the government be the one going inside and telling them, well, can you boost this sort of product and others? Well, of course they can. My wife, for whatever reason, sees a ton of this like pro-Hamas propaganda. I don't know where she's getting it for some reason, but they luckily censored it for me, where I'm not getting exposed to all this like anti-Israeli nonsense all the time on my social platform. They figured out some algorithm that I don't want that as much, and that's fine. That's what they do. That's what they literally have to do. Is I think it was the lawyer Paul Clement in the oral argument said, if there was no censorship, or to use a better term, definitely sort of prioritization here, social media would just be a gobbledygook. Half the stuff you received would be in a different language. You wouldn't know where it came from. And then once you get into the question of like, well, this is censorship if you're sort of de-emphasizing this, and this isn't. Those are impossible line drawing questions that to me just can't really be done effectively by the government.
What are the next steps in considerations? Like, what's happening? Like, what are the next things going on?
So if HB 20 passed, there's a similar law in Florida that passed. Those have been argued before the Supreme Court, and basically we're waiting for guidance from the Supreme Court about whether those are constitutional Supreme Court's view, and then that ruling will, I think, dictate other state and federal laws.
We'll know more in June.
I have a question that maybe boils down to the size matter. I've learned a little bit here that there's some threshold in how you treat a company, whether they're small or not. So if I'm selling, so that's kind of one question. We use a telephone analogy, and I guess go to the extreme as a megaphone in some sense that if I walk by, I have to hear the person in the social networks. Maybe not write anything, not to opt in perhaps to listen to someone, except that there are advertisements on there that I don't opt into. So it's sort of partly megaphone and partly a fixed network, it seems like. And the other question would be sort of related to the cake, Colorado cake. I don't clarify to me what I understand. It's like I'm trying to force a company to make a custom cake, and they were allowed to do that. But if they had a cake that was already pre-made, the cake person, I assume, was allowed to buy that cake. And that there's a distinguishing between customization and generic products. Sounds like y'all are talking around generic product.
And I think this goes to the case that was mentioned about early. So I think it's partly a function of market power, but it's also a function of expressive First Amendment protected expression. So Hurley was a case of a parade. And I think that the way, at least I read the Supreme Court case, what they're really saying is that the decision about what floats go in the parade and don't is necessarily imbued with expressive First Amendment sort of expression. And the same thing with the cake, that it's an expression of that person's sort of ideas and sort of beliefs, which again is sort of distinguishable in my mind when you get to sort of this massive level of sort of general use types platforms that they're not really, in my view, sort of expressing their First Amendment views and values, given the way that they operate. But
yeah, I mean, the case that was decided last term was a web designer, Christian web designer, and it was very different. It wasn't. She was a wedding. She designed websites for the weddings, and she made special artwork for each wedding, and each one was imbued with a particular message, and she worked on the text, and she pre-screened all of her clients. And the whole, you probably know more about actually how the litigation was created, but a gay potential client said, I want the service, and she said no, because I'm too involved in the actual expression, that these websites are my speech. And that's really what this whole really boils down to. If the platforms are, if when you put something on the platform, you're expressing Twitter, you're expressing Mark Zuckerberg, then there's a First Amendment protection, and these sort of requirements of non-discrimination are probably unconstitutional. If these platforms are just sort of bearing the message, then they can be regulated like any other business. You correctly point out that it's like kind of in between. I mean, how do you figure it out? And this is where it's an interesting sort of question. I mean, if the law says that they're carriers of speech, they will become carriers of speech. If the law says they have the First Amendment right to censor and to create their own little environments, they'll do that. And it sort of reminds me when Larry Lessig said, code is law. Well, law is code. And, where the court comes out of this, I think will push developers in the form and structure of these organizations.
Yeah, Judge mentioned boosting several times. Most of the panel didn't very much. In a lot of ways, boosting and shadow banning are more important than censorship because it doesn't really matter if we can say something if no one hears it. We can find out about it. So I just wanted to see from the rest of the panel if what they advocate applies to deboosting and shadow banning in addition to just outright censorship.
Yeah, I don't, some people have articulated the view that, freedom of reach is different from freedom of speech, and I don't really sort of believe in that. I think, yes, there should be prioritization. Yes, there should be sort of algorithms, but I think what you do is you simply say, there is a risk of the government trying to superintend. The government shouldn't be picking, what speech goes and what speech doesn't go. That's problematic. I do think what you can take out of the algorithm, it's difficult, but basically for all that prioritization you do, don't do it based on viewpoint. Religious, scientific, political, and I'm not saying it's easy, but I think that's where we have to try to strive as a public policy manager. For all your boosting, prioritization, and reach, don't do it based on those sort of protected qualities, but yes, you get to still do it.
Yeah.
Quick question there, just what did you say in some sense that the vast majority of what happens on these platforms is viewpoint, and even a large majority might be these protected classes on it? So, okay, no, please, yeah.
This is not me, this is the platform speaking. Tama involved in exactly this issue, whether to boost terrorist speech. And because the claim was that YouTube, by making recommendations, was in fact endorsing terrorism. Because there are all these, guys in madrasas, and they were watching YouTube videos and led them into the argument was it led them into terrorism, and therefore YouTube was responsible. Google was responsible for these algorithms because it was leading them down this road of radicalism. And YouTube represented to the court. These are neutral algorithms. All the data comes from our users. They represent neutral tools that were simply reflecting our users' view. Now, of course, they say that when they want to avoid criminal liability under the anti-terrorism statutes. Now we're here, in 8-20, and they're saying, oh no, these algorithms are our own perspective, our own views, our own values. And so, in a way, it's a technical question. Are these platforms, these algorithms neutral? But the platforms have represented that they are, and that can you define themselves?
There was a question in the back.
Oh yeah. So some people would make the point about that the platform puts itself forward as generally these platform, therefore these laws apply to it. So I'm just imagining that if I'm one of those platforms, I'm going to just put a really thin veneer on top that says this is not a general use platform. Or when you sign up, you have to wait 5 minutes for some person in India to say yes, approved, so that's not automatic. So how would the laws respond to that sort of malicious compliance where I just say, okay, maybe in the past I said we were general purpose free speech, but we're not anymore, so back to business as usual.
Well, I think if they did that, I think one, it would go a long way to have some, transparency, even if it is sort of a veneer. Two, I do think it would make it more difficult, as a First Amendment matter. One example is actually the net neutrality rules. There was a plaintiff actually from Texas called Alamo Broadband. They said, we want to create, potentially, a curated internet experience. And the DC Circuit effectively said, the way we are going to sort of interpret these net neutrality rules is they're only going to apply to an ISP that holds themselves out as connecting people to basically every endpoint of the internet. And if you say, I'm offering a curated internet, then you're out of net neutrality, and ostensibly you're out of Title II as well. And so the same questions come up. Could an ISP say, I'm going to connect you to almost all endpoints, but there's some, family friendly or some veneer, and then get themselves out of Title II and out of net neutrality? But I don't think a difference of view, but I do think it would, it could get people out if they put a veneer out.
Yeah, this is the same question in the 19th. Yeah, the same question in the 19th century. There were railroads that had specific requirements they only wanted to serve Western Union or things like that. And the court said, well, they looked at the function and said, well, can you serve everybody, given your capacity and investment in your industrial structure, and would disrupt your business terribly, and it's pretty much what you're oriented to do. And they said, yeah, sort of a rule of reason sort of approach. This sort of veneer stuff probably wouldn't work, but if you really were a sincere company and you just wanted to connect Christians or Republicans, I think that the courts would probably recognize that.
Let me try it this way. The law, HB 20, is only triggered for platforms that are open to the public, quote unquote. What does that mean, right? We've heard a couple of panelists mention the Prune Yard case, which was decided, I think, in 1970. And the thrust of that case is you've got a big shopping mall that's open to the public. That was one of the core rationales, where the court says, okay, open to the public, they can be forced to let people pamphlet on whatever they want to pamphlet on, right? Because they're open to the public. Does that case come out differently if the mall says, no, we're not open to the public anymore because we don't let you in with flip-flops, you gotta wear shoes? Are they not open to the public? I think they still are open to the public, and then like you could take that out a couple of chains, and at a certain point, maybe they really are no longer open to the public, but where is that? It's not easy. There's no easy answer.
Okay, just to get this judge asked the hypothetical gentleman you were saying, so which is that like what is good policy rather than false amendment, and then Commissioner Carr has kind of talked about a spectrum of telephones to news vehicles, but I think there is a spectrum between when people know platforms, and as the last judge or anyone else is, I kind of do get that when it comes to how whether the government should be regulating the algorithms of Twitter or Facebook, especially when there's a lot of, you can get harassment comments is one thing. But on the flip side, apparently this is regulated by HB 20, but it's taken one Cloudflare, which is effectively a monopoly, which prevents people from getting DDoS attacks, which is a felony. And Cloudflare has said, someone's a neo-Nazi, like we want to allow people to commit felonies to shut down or First Amendment protected speech, and they've done that with absolutely no legal sanction. Or something like, Amazon Cloud was one of a few of these things, and when you give us platform control, it takes months for them to re-upload it to another thing. And it basically destroys a business based on allowing First Amendment protected speech. And then even in the middle of YouTube, it's kind of not clear how banning, YouTube video can be harassing or anything like that. So I guess to everyone, do you think that there are some social media cases where it's more compelling to allow government regulation versus others, I guess?
Okay. And I guess it goes back to something that Judge talked about. Why do we have these anti-discrimination requirements? And in the beginning of the 20th century, this Harvard law professor said, oh, it's because of market power. It's sort of this old proto-antitrust law that developed in the 14th century. But if you actually do the research, it's not at all. I mean, innkeepers, even if there were 2 innkeepers in the village, they had to offer their services to all. Even if there were 2 farriers, so that people would put horseshoes on horses, they had to serve everybody. And though what these laws are really about are ensuring that there's certain kinds of things, certain kinds of basic services, where there is conceitedly large, initial investment and low incremental costs. So these companies have large capacities and can serve people in an indiscriminate way, and that are vital for sort of social and political goals. And I just don't think it's the end of the world if we hold a few of these companies, to these duties that their predecessors had for hundreds of years.
I would say the predecessors didn't have the duty to, again, allow anyone to talk at the end, allow anyone to express certain things on the railroad.
The Telegraphs did.
The Telegraphs had to carry all different sorts of messages and wherever they did. And in general, we allowed, again, we have these certain things that discriminate for the pipes and the wires we agree on, but I agree with most of the conservatives who oppose net neutrality, which trying to impose very similar mandates on the ISPs, which are much closer analogy to the telegraphs and the cable companies and so forth than the social media companies. Now, to my mind, the market power argument, like to some extent the professor just pointed out, might prove too much, because if you look at, say, the typical network effect analysis, which is, as Carl said, he brought up, it's a two-sided market. That's the base of a network effect, not the sort of production function of a particular company like a railroad. And it takes people, individuals that are joining the market, who are trying to connect with advertisers, and the platform is the intermediary there. Now, if you look at that market as like the share of ad revenue, Facebook and Meta just dominates everything. It's all basically Facebook and Instagram is like 70% of the ad media market. Twitter has 6% of the social media ad market. I mean, this by any sort of definition of this behemoth market power would not fit right there. Things like Snapchat and Reddit and all of these other social media, they have fairly small amounts of the market. I mean, and again, they seem to compete with each other pretty well. Their market shares go up and down pretty regularly. This doesn't look like something that needs to have the government step in and decide this thing. Sorry, I'll back up for one last second on that. The only plausible argument in my mind has to be that there is some sort of market power, that people cannot get away from these social media networks, and that's why the government has to step in. And if you look at a bunch of these companies, they don't seem to have much market power, and they change very quickly. The other argument about, well, they're holding themselves open to the public, that gets to what the commissioner says about, well, then maybe they have to express themselves what their job is differently. And to that, I can be pretty sympathetic that, okay, they do have to say maybe a little more. We're not quite a public-facing activity. We have a certain niche market that we're going for, whether that's Snapchat or Reddit or WhatsApp or whatever it is. They're expressing different type, or expressing is the wrong word for the First Amendment, but they have different sorts of platforms they're providing right there, and that's okay.
Just in the interest of time, one last question, I'll let you ask, sorry.
Rapid fire.
So it seems that the four of you might disagree on whether we should have government try to interfere in order to preserve some sort of more diversity of speech and representation out there versus other market-based versus like some regulatory framework-based. But I haven't heard any of you saying something that is a cultural problem that Commissioner Carr addressed at the beginning. Like, well, there's some people out there that actually think we should shut people down. That there's some because otherwise it affects democracy, because otherwise it affects public health, because otherwise. So none of you are concerned about bad speech. All of this would be like, whatever, let's speech be free, right? So, but clearly there's a divide in the country on this, and we're here trying to argue on sort of like details of how. If I can say this, our side is going to address the problem. Versus what the other side is saying, no, shut it down. Shut it down. The other side is pretty big. Now, and maybe I'm exaggerating the position of the left on this. I don't think I am. And I'm going to use international frameworks that are happening right now on the same type question on the social media platform that's happening in Brazil, in Canada, in England, in France, and so on, where censorship is just like taking a whole nother level. Right? So we Americans here are like, well, we have this thing, and we're our stuff. So anyway, just do you have any comments on like what do you see happening elsewhere that is coming our way through that worldview that's represented perhaps on the other side of this question?
4 years ago, as we went to COVID, I did an op-ed on sort of a similar topic, where the theme of it was misinformation is the new misinformation, meaning that people are slapping the label of misinformation. Now, I was wrong in the sense that the disinformation is sort of taken over, but the same point, right? People are taking political speech, political ideas they don't like, putting the label misinformation, disinformation, or increasingly hate speech on it, and then using it to censor it. Hate speech is one of these issues that people always get wrong with, is fully protected by the Constitution. Right? There is not a bucket of speech called hate speech that is not protected by the First Amendment. And yes, your point, this is a cultural issue that we have to continue to speak and fight about and try to get back to that sort of 1970s sort of view. But yeah, your point, we see it around the world as well. And look, right now we're seeing it in Cuba right now, right? As soon as people take to the streets, any part of the world, and they fight for freedom, what's the first thing that they do now? They take out their phone, they take videos. When that video gets out, it shoots around the world in an instant, and it accelerates the decline of regimes that govern without the consent of their people. That's the power, and that's why
then the governments use all those videos to put everybody that was remotely close to it in jail. That's what happened in Brazil.
Well, yeah,
January 6th.
Yes, yeah, but two things. Well, yeah, but fundamentally, what happens? People take their phones and they take video. What does the government do? They shut the internet down, or they block certain applications, right? And so, to your point, we're seeing this sort of global surge towards censorship that I think we have to fight and push back on this idea that there's a bucket of speech called hate speech that's unprotected by the First Amendment.
And just to emphasize that, this is a lot of this behavior and belief is horrifying. Again, that a lot of people, the New York Times, think a U.S. senator should not be allowed to talk to the public. But the Chinese Communist Party should be. I think that is a unbelievably worrisome balancing test that they are carrying out right there. What should the government do about this? We all agree that the government can't tell the New York Times to publish cotton and not publish CCP. And in general, I think we all agree the number one issue is we just have to convince people that's not a way to look at society and free speech. I know Richard says, of course we can tell people how to believe in that. No, because what happens is the government's going in and telling people this is the sort of stuff you should carry, this is the stuff you shouldn't carry. Yeah, please.
I mean, the EU has just passed the Digital Services Act. This is a censorship law that requires the platforms to take off hate speech, and everything is hate speech in Europe, and they define it broadly.
You want ice in your soda? That's hate speech.
That's hate speech, yeah. and actually disinformation, and requires, unlike Murphy, doesn't require, the question is whether, the regulators and the platforms, whether they collude, that's a First Amendment violation. This requires the regulators to go to the government and collude, and the platforms are required to pay government-approved flaggers to get censored. Now, that puts the platforms in this question. Do we have two Twitters? Do we have two Facebooks? One for Europe, which is enslaved by their typical tyrannical ways that they've always done for centuries, or one that is free and American? Which would be cheaper for the platforms to do? There's one, the European model. And really the only thing standing in the way of that takeover is HB 20, because censorship under the DSA would be unconstitutional.
Or can they just do what Pornhub did and say, well, okay, no more break.
Or they can pull out of Europe, that's right.
Or Texas.
That's right. That's right.
In case you guys don't know, maybe some of you don't, you cannot access Pornhub right now. I read this in the news. It was in the news.
He is not tested.
I tested. Just want to tell you, it came on like MSNBC, not because I typed in Pornhub.com.
Well, that's right. I mean, whether we'll have a balkanized approach, and so in a way, the question isn't wouldn't it be great if government didn't get involved? It already is, whether ours or some other company.
Well, with that, let's thank the panel.